So an absolute ton of news was broken in South Carolina this week, and at FITSNews, we covered all of it. There were sentences handed down in Lexington County on a brutal gangland killing involving multiple teens, some real accountability in that case. In Richland County, we reported exclusively on allegations of grand jury fraud, which, by the way, are now the focus of a state law enforcement division investigation. South Carolina Attorney General Alan Wilson came out hot this week, saying no more clemency bids for convicted killer Jared Price, who was released illegally and unconstitutionally from a Palmetto State prison earlier this year. Speaking of those prisons, we exclusively reported on a big scandal at Lee Correctional Institution, where 2 former correctional employees were arrested this week, charges tied to bringing contraband into these facilities. Also, we reported on a big political scandal involving our former governor, Nikki Haley. We also reported on an arrest that was made in connection with a fatal teen pursuit car crash that took place back in July, claiming the life of a 16-year-old. A ton of stuff happened, but are we talking about any of it on this show? No. And why not? The Murdaughs. So 2 weeks ago on this show, I talked about having a bit of Murdaugh fatigue. And if you followed this case, you cover this case, that's understandable. It's been going on for a long time, and it's starting to dawn on me that this story is never, ever going to end. But this week truly had, as we predicted it would, a seismic detonation. And I want to back up to just before the Labor Day holiday, last week, right before we entered that long Labor Day weekend. And I got a call from a source very close to this case who indicated that Dick Harpootlian and Jim Griffin, Alec Murdaugh's 2 lead attorneys, would be dropping what this source called, and I quote, a nuclear-sized turd in the punch bowl. It's an interesting turn of phrase, but of course I responded, well, we'll see. We'll see. And we hear a lot. Dick Harpootlian and Jim Griffin, both very adept attorneys, but they're also master showmen. They know how to work the press. So, okay, we'll see. We'll see what they've got. But folks, did they ever deliver the goods? This was a story that actually, I believe, turned out to be bigger than advertised. And we were already expecting a major revelation. But what we ended up with, both in its depth and its detail, and how well documented the allegations were, proved to be a truly paradigm-shifting moment in this ongoing story, which again, depending on where you start at 5 years, we're in year 5 of this story. If you date it all the way back to that tragic boat crash in 2019 that really launched the Murdaugh murders, crime, and corruption saga. But as we look at what happened this past week, allegations of jury tampering against Becky Hill, the clerk of court for Colleton County. Now, Becky Hill was accused of multiple crimes, really, in this filing by Harpootlian and Griffin, telling jurors to disregard certain testimony, telling them to watch Alec Murdaugh's testimony, implying that he was not to be believed as he was testifying on the stand during his double homicide trial. The most seismic allegation, though, allegations that Hill conspired to have a juror friendly to Murdaugh removed. But a whole host of allegations raised in this filing, and perhaps even more significant than the filing, which demanded a new trial for Murdaugh, was a request for the federal government to get involved and to investigate Becky Hill related to these allegations. Just a paradigm-shifting moment in this narrative. And as we walk through the fallout of all this, I want to start with that request for a federal investigation, because to me, the criminal probe, potential criminal probe tied to all this is more significant than the request for a new trial. I think Alec Murdaugh's going to get a new trial because, as I mentioned repeatedly, including on our Fitz Files podcast earlier this week, if even half of what is alleged in this complaint from Harpootlian and Griffin is half true, Alec Murdaugh will not only get a new trial, he will deserve a new trial. You can't put your thumb on the scales of justice, people, no matter who you are. No matter who you are. And even if it's an innocent conversation, that little thumb creates an unfair and, to quote Harpootlian and Griffin, unconstitutional infringement on Alec Murdaugh's right to a fair trial. And we're going to talk in just a moment about that standard for a new trial. But first, I want to talk about the criminal investigation. I fully expected federal authorities and federal prosecutors to announce that they were in fact probing this allegation of jury tampering. But on the very day after it was made, we heard from a very well-placed source, a good journalist who's been tracking this story a long time. We heard that that might not happen. And shortly thereafter, we began receiving information from the attorneys close to this case that, yeah, the feds, initially anyway, appeared to be taking a pass on this. And that shocked me. If you watched our Fitz Files episode, I expressed little doubt that the feds would jump in. But apparently the hook here is that we are dealing with allegations of misconduct in office. And if you're not familiar, these are state charges. There's common law misconduct and general misconduct in office, and they involve public officials who, in the discharge of their duties, commit misconduct, commit crime, sins of omission, sins of commission. And so because this is not a random person who's being accused of these things, because it's an official of the state, an elected official, incidentally, clerk's court elected in South Carolina. Because of that, the feds apparently believe that this is an investigation that they cannot initiate. Now, it will remain to be seen whether there is a nexus to constitutional violations of Alec Murdaugh's constitutional rights. So that could be an opening for the feds. But as of now, the investigation, for better or worse, being led by the South Carolina State Law Enforcement Division. Now, we first reported on that investigation the night after these bombshell allegations were dropped, and SLED confirmed that they were leading that investigation the next day. The question is, should they? And I've had a lot of talks with a lot of people about that, because anyone who doesn't believe SLED has a vested interest in the conviction of Alec Murdaugh being upheld, again, I don't know what planet you're on. I don't know what story you've been watching. They clearly do. And while I've heard from my sources at SLED that they are only interested in upholding justice, I think we've got to look at that with an ocean of salt. They are heavily invested in the outcome of this case. And I think to suggest otherwise strains credulity. But we're going to dig into that in a little bit. But before we do, we need to address the other part of this story, which is the request for a new trial, which, again, as I've said, I don't think there's any way Alec Murdaugh does not get a new trial. But our director of research, Jen Wood, who knows more about the Murdaughs than anybody, sat down this week with somebody who knows that case law, who knows the standards that must be attained for a new trial. And they had a far-ranging discussion, starting with that, but it delved into a lot of other things. And I'm referring, of course, to attorney Mandy Powers Norrell. She's a former state lawmaker. She's currently a prosecutor up in the South Carolina Sixth Circuit, in addition to having her own legal practice. But Mandy Powers Norrell, just a super sharp attorney who knows these cases back and forth. She sat down with Jen Wood. Let's cut to that conversation.
So I am here with Mandy Powers Norrell, who is one of my favorite attorneys in South Carolina. She is a former state representative, former candidate for lieutenant governor, and one of those lawyers I know I can go to get a unbiased, fair, and intelligent perspective on my legal questions. And I saw you're on Twitter and you have a lot of followers. And after all of the madness in terms of the allegations and within the request for a new trial submitted on behalf of Alec Murdaugh by Dick Harpootlian and Jim Griffin, I saw a tweet that you did, and I was like, this is what I need. I need somebody without an agenda to explain legally what's happening. So I was hoping, to talk to you and hopefully get a sense of, your thoughts on this, and kind of go through the process as you know it from a legal perspective, without an agenda, without skin in the game.
Right, right. And, you know, and I do like, I have an opinion on guilt or innocence, but this to me is a very, it's a different matter. It's more based on procedure and standard of review and just what the law says. And when I, you know, read the filings by the defense, first I tried to guess what it might be. You know, are they going to say a juror was looking at social media, or somebody, you know, from the outside influenced a juror? And then you would have a standard of review of harmless error, you know, and the question would be, did it change the ultimate outcome of the trial? That's a very high standard. And that's why most criminal appeals are not successful, because you can't show, the burden of proof is on the defense to show that it would have changed the outcome. And you really can't show that it would have changed the outcome very often when there is sufficient, sometimes overwhelming evidence of guilt. And so that's a difficult burden. So they would have to like lower the burden and change the standard of review. And one of the ways to do that is if the outside of the jury communication came from a court official. If in that case there is a South Carolina case called State v. Cameron, and a U.S. Supreme Court case called Parker v. Gladden, which changed that standard of review from, is, you know, did it change the result, to could it have changed the result? What a difference that is.
Right.
And
Right.
so, you know, when you have court officials, they can only talk to the jury about things that aren't analyzing evidence or expressing opinions about guilt or innocence and that kind of thing. In the Parker v. Gladden case, which was from 1961 and seems to be, you know, sort of the cornerstone case about court officials talking to jurors, a bailiff said to two of the jurors, one was actually an alternate, and I don't know if she ultimately got on the jury, but they were going into deliberations, and the bailiff said, "Oh, that wicked fellow, he's guilty." And because the bailiff said that, I mean, apparently there was overwhelming evidence of guilt in that case. However, because the bailiff said that to a juror, the court determined that, well, that could have influenced the juror because he was a court official, and that could have changed the result. No evidence that it did, but it could have. And that's where that standard of did it change the result gets lowered to could it have changed the result if it's a court official. So that is I am very interested to see if the state argues that there is a different standard of review. This is all we've heard from is the defense at
Right.
this point. And so the state may argue, no, we are at the did it change the result standard of review, which I don't think they get a new trial if that's the standard of review. I want to hear an argument that that's the one we apply, as opposed to the one that seems to me to be clearly the one to apply.
Yeah, I mean, everybody's all like analyzing every little paragraph of that 65-page motion.
Yes.
And I probably 5 times a day, I have to tell somebody, I'm like, you need to remember this is just the defense's side of this. And
Right.
they are presenting the information
In the
as
best light
in
for
the best
them.
light for them. And we have not yet seen the state's response. We don't know how that's going to play out.
Mm-hmm.
And you know, if you pull apart all of the allegations, you know, if a couple of them aren't true, it could totally change
Right.
the end
Right.
game.
And if you look at these affidavits, you know, line by line, you know, I would read them one line at a time and get to the end of so many sentences and be like, so? You know,
Right.
and then read another one. So?
So
But
two
in
jurors were
the end,
alone.
right,
You don't know what they said. You weren't in the room. They could have, you know, been
exactly.
exchanging, you know, somebody
Yeah,
borrowing a cigarette or something.
right, right. They could have been talking, which I think is very possible, about a problem juror, you
Right.
know, who's being disruptive or just inconsiderate to other jurors. There are so many, you know, interhuman problems that come along when you're dealing with a you
Right.
know, a community like that, a jury. It's there's so many things they could have been talking about. So I read that and said,
In
so?
terms of court staff, I mean, I think
Mhm.
to me, most court staff they're very aware of that rule about how they should interact with the jury, if at all.
Right.
I think as limited interaction as possible, only, only to make sure they're comfortable, they have what they need, no discussion of the case. So were you as surprised by the allegations as I was?
Knowing the stakes, I was not very surprised by the allegations,
Right.
because if they're going to get a new trial, the best way to approach that is to find any communications from court officials and then turn, and say that
Right.
they were designed to or could have influenced the outcome. That's their best shot. So to that extent, if they're going for the Rimmer hearing, that's the way to go for the Rimmer
Right.
hearing. And also, just knowing that the clerk of court wrote a book that also brings into question some things about, where her, if her judgment was at the right place.
I was
And
going to ask you about that because I did see in an interview, her co-author, Neil Gordon, had said they had checked with the Ethics Commission to see if it was, if it was okay if they wrote a book. And I think a lot of people, when it came out, questioned if that was okay, including myself. Do you think that ethically that was okay?
Yeah, I think it's okay ethically. I think there's a question between, is it legal? Is it technically, does it violate an ethical canon? Or is it a good idea? Are you opening yourself up to every line being scrutinized and attacked? And, if I'm on the defense, I'm grabbing that book as soon as it comes out and saying, let me see if I can get a Rimmer hearing out of this. And the best excerpt they got was that she had talked to jurors with her eyes. And I speak eyeball. I know what they're talking about. I know what she's saying.
Most women are like, oh yeah, I see what they, I can see that happening. Yeah.
And so, and that is, if it's characterized as communication, that's an admission of communicating to jurors or to whoever else was there. And she mentioned jurors. She's like, they knew and I knew, and we told each other with our eyes that he was guilty. So that in and of itself could be interpreted by some courts to be an admission of communication about guilt from a member of court staff. I don't know that jurors took it that way, because we don't have any affidavits from a juror saying she told me with her eyes that he was guilty. So for it to be communication, you have to have a sending and a receiving. So I think that might, if I'm the state, I'm saying, well, that fails. That's not a communication. So she can't admit to a communication that wasn't received.
So procedurally, the defense has filed this motion, so they had to stay their appeal, and their motion is filed, within the circuit court, the trial court. So we have 10 days for the prosecution to file a response. And then do you think they file a response, or do you think they're like, oh, well, maybe he does need a new trial?
No, I think there's enough. If I'm the prosecution, I'm fighting this every step of the way. Look at the resources the state put into this trial. It is, hundreds of thousands of dollars when you combine, both sides' resources. It is so much time, so much docket time. If you're like a defendant waiting for your trial to come up in the 14th Circuit and Alec Murdaugh keeps jumping ahead of you, that's not fair to the other defendants. It's not fair to other victims. It's something that the equities of it are just such that for everyone's sake, I think that, if he didn't get a fair trial, he needs to get another trial. But for everyone's sake, I don't think the state is going to want to roll over and just say he didn't get a fair trial. And I think there's enough in the affidavits that they can attack, but everything was thrown in here, the kitchen sink and everything. So they're going to have to go piece by piece and address every little thing But when you look at all the allegations in the affidavits, very few of them relate to communication by a court official.
Right.
And that's the only one that has that lower standard that could, I think, actually get them a new trial. The other ones have a standard that's so high, I don't think they could overcome
Right.
it.
But no cigarette breaks.
Right. That's
Like,
why
I
put
mean,
that in there, really?
my friends who smoke are like, well, that's a game. I'm like, well, I don't think legally it's gonna.
But it's not saying no cigarette breaks until you find him guilty.
Right.
It's,
Right.
we got to get this done.
Right.
Which, if that's a problem, you complain about it at the time. If you don't complain about it at the time, that's the end of that.
Right. So when they get both of these motions, or when the prosecution gets a response in, a judge is going to look at this and determine whether or not there should be an evidentiary Remmer hearing. Correct?
Yeah. So probably a panel at the South Carolina Court of Appeals will look at
Okay.
it and decide if there will be if they will suspend the appeal. Rule 29 requires that you cannot have a Remmer hearing. You can't make a jury contact allegation and have it be heard during the pendency of an appeal. So because the appeal is pending, they have to ask the Court of Appeals to suspend it for the Remmer hearing to happen. So if they suspend it and if they grant the Remmer hearing, then they'll go back to state court to have that hearing.
Will Judge Newman recuse himself, do you think, or do you?
I don't
the
think
man,
so.
Yeah.
I know there is the statement out there, well, he's a witness. Well, so are all we, so are the attorneys, so is every party and every participant in this. It's not, witness once a trial has happened and you're having a hearing about the procedure of the trial. Everybody involved is a witness. So I don't think he would recuse himself just because he was, a part of conversations regarding the dismissal of the juror and all that. So
Yeah,
I would hope and believe he would continue as the judge.
Let's see. So in terms of a new trial, let's say the absolute, this is the last thing I want to even think about, but let's say they say, yeah, he needs a new trial.
Yeah.
Is that going to be a year from now? Is that going to be 2 years from now?
I don't know, but I do know, if Judge Newman is going to hear it, he's in retirement, he's retired active, coming back or he will be coming back and working as retired active. And I think they would want to get it done before he is fully retired. And so it's something that I would expect would probably be done fairly quickly because he does have a right to speedy trial and all this. I also wonder if he's granted a new trial, if he doesn't just run and plead guilty to all of the federal charges so that he is then sentenced and serving in. That's
what I think. He's
in a federal prison.
Yeah, the second I saw that change of plea, I was like, oh no.
Yeah, it's a lot more comfortable in the federal system, generally.
Do you think if there is a new trial that they're going to change the venue this time?
I don't know about, I don't think it'll be Colleton County because of the implications about the courthouse. Because if they grant a new trial, then what they're saying is there was improper contact by a court official. So I think it would be another courthouse. It might still be in the same circuit. But, if you change venue, you want to have a venue in which the jury pool is going to come from the people of a similar demographic as the peers of the accused. And so there aren't a lot of places in South Carolina like Colleton County or like Hampton County. And so I think maybe Dillon County would be a possible venue, but it would be hard to find a comparable venue in South Carolina to give the accused a jury of peers or similar peers from the community. Greenville County, Richland County, they wouldn't work.
Yeah,
So
I mean, I was talking, I think it was Jack Swirling about this before the trial, and he said, juries in urban areas are far different than juries in rural areas,
right.
and you really have to take that into consideration when you're preparing for a trial like this. And I was like, oh, I hadn't even, stuff I didn't think about because I am not an attorney. I just play one on TV. Do you think the jury should have been sequestered the first time around? Most people say it wouldn't have made a difference.
I don't think it would have made a difference. And it would have been so hard on them. I think it would have led to a lot of dissension among them. It's so hard to be with 11 other strangers in, just 8 hours a day. It would be super hard to be with them 24 hours a day. And again, that's what I suspect they might have been talking about in the bathroom when they were allegedly, talking in the bathroom. It's something that I think is just the judge weighed, the risk of them getting outside information. But ultimately that's not what the issue is. Nobody's saying they were out there doing independent research or that, the third parties were coming in and telling them how to vote. And if they were, the bar would be a lot higher for a new trial. But that's not what they're saying. So sequestration would not have made a difference in these allegations.
Yeah, I agree. And then, so one thing I want to talk about is that people are in an uproar that SLED appears to be taking the lead in the investigation into the criminal side of this because they do have a vested outcome. Do you have any opinions on that?
I think that, it's probably not the most popular opinion, but, SLED that's who investigates state crime.
Right.
And if there's an allegation of violating a criminal statute in South Carolina, SLED would be the entity to investigate that. To jump over SLED, you'd have to be able to show that they can't do it effectively. And I don't know that has been shown. It may be ultimately shown, but I haven't seen it.
Right. Do you think an independent third-party oversight or something like some sort of would help?
I've never heard of that. I mean, I don't think there's
I don't even know.
That.
I don't even know. I don't know what the answer is. I mean, I understand the concerns, but I understand that legally that's where it goes. Where else are you going to take it?
Right.
So yeah, it's an interesting conversation, but I don't know. I mean, So I think for me, the hardest part about this is that I know so many lawyers like you that are honest and I mean, just good people. And you see these filings and these allegations and you're like, who's good, who's bad? And
who's just advocating, because I mean, when I have a client, I'm advocating for my client, and it might not be a side that I would pick if I was just picking, but a lot of these lawyers are just advocating, and it's a matter of who hired them and what their job is. And we all have, everybody's job in the process is an important one. And I think a lot of times we villainize lawyers who are really just advocating.
And strong defense attorneys are key to a good judicial system. I mean, it's key. If we don't have that, everything falls apart. So, while they get villainized by a lot of people, I have a lot of respect for them. And honestly, some of them are the smartest people I've ever spoken to.
Yeah.
So,
and I would take when Alex testified, if I had been his lawyer, I would have wanted to walk out the back door. I wouldn't have had a thing to come back and say. And the fact that Jim Griffin could redirect after that, I had so much respect for him.
I feel like I saw glimpses of that in their faces. But and then I wasn't surprised. It was like, I'm not surprised, but I'm surprised. And how do you come back? How do you come back from that as a defense attorney?
Right. I think I just would have. I think I would have just spaced out.
If he doesn't,
It
If
was
he gets a
amazing.
retrial,
Yeah.
these are huge. Like, these are ifs.
Big ifs.
Oh goodness, I don't want,
Hmm.
if he gets a retrial and he decides not to take the stand,
Which would
is
be
the
smart.
test, yeah, is the testimony from his first trial admissible?
Yeah, I believe so because it was given under oath and he
Yeah,
had waived his right, his Fifth Amendment
right.
privilege at that
I
point.
mean, if he takes the stand, he's risking impeachment.
Yeah.
Like, what are you going to do, buddy?
Right. He's going to have to either tell the same story or explain why he's telling a
Right,
different story in a very believable way. And I think he thought the story he told was believable, but jurors and just us as humans, we have a way of separating what's true and what's not, even in the face of being told something that we may really want to believe because we're accommodating people. We want to believe that somebody's not lying to us, but our body tells us what's true and what's not true. And
right.
I think clearly, as they said afterwards, they felt it.
Yeah. I felt,
I felt
I was
it.
like, oh.
It felt like having a boyfriend who cheated on you and they were telling you that they hadn't cheated on you
Yes,
and coming up
yes.
with all of these like stories about, well, see what happened was
What,
this. You believe me, right? It felt just
and
like
you
that.
couldn't stop watching. I mean, it was like watching a train. I was like, what is happening? I can't believe this is happening.
I've watched it so many times.
I have to. Yes. Well, thank you so much for
Thank
your
you.
time and always being just
Thank you. Thank you
one of
for
those
having
people
me.
I know I can trust to. It's like,
Thank
okay,
you.
what does this mean? Straight talk, textbook. I don't want to know.
Thank you.
Thank you.
Thank you for having me. I've enjoyed it.
So what a compelling conversation there. Our research director, Jen Wood, and attorney Mandy Powers-Norrell, who, again, provided such a broad range of insight on so many facets of this case, but particularly I want to zero in on what they were talking about there toward the tail end of that conversation, the admissibility of transcripts, particularly transcripts of Alec Murdaugh's testimony from the first trial. Do they come into the second trial? Guess what, folks? Yes. Attorney Eric Bland, one of the first on social media to talk about this, saying yes, they will come in. And again, he's right. Barring some hearsay exemptions, that's coming in. And that creates a huge hill for Murdaugh and for his attorneys because remember, some damning admissions were made by Alec Murdaugh on the stand during his testimony in the first trial. And not only that, Murdaugh was walked into additional lies while he was testifying. Creighton Waters masterfully led him down that primrose path into yet another lie, exposing for those jurors that, in fact, he was lying as he was testifying. So all of that coming in to a second trial in the event Murdaugh's attorneys are successful in getting a second trial. I also want to point something else out that I noted at the press conference where Dick Harpootlian and Jim Griffin were raising these allegations. They were asked point blank whether or not there was any new evidence regarding another suspect. And they definitely pivoted and said that right now we're focused on getting our client a new trial, which, read between the lines there, folks. They know this guy's guilty of sin. This is about process, not about finding the, quote, real killers. So I want to point that out. That's also something to bear in mind as this process unfolds. Also, one other thing, and our director of special projects, Dylan Nolan, pointed this out to me as we were filming this episode, and it's something that I have written in most every story that we cover regarding allegations like this. They're just allegations. Clerk Hill, Miss Becky, someone all of us got to know very closely during the 6 weeks in Walterboro. These are just allegations. They are credible. They appear to be very well documented. And again, as I mentioned, our initial intel from the law enforcement inquiries being made related to them are that there is something to them. They are still allegations, and the burden of proof in the event there is any criminal consequence related to that, that's going to fall on those accusing her. So I want to point that out. Just as Alec Murdaugh is entitled to a fair trial in an actual courtroom, Becky Hill entitled to fairness as it relates to these allegations against her. And we want to point that out. That's very important. And also I want to point out we're still waiting, as we tape this episode, still waiting any word from her attorneys, Justin Bamberg in the lead role there. Still waiting for any sort of comment from them as a response to this. And in the event we get that, we will bring it directly to our audience. But all this continues to unfold, and as we look forward to this coming week, another big week, we are headed to Beaufort, South Carolina for a status conference. Thursday, September 14. Alec Murdaugh will be there. It will be his first appearance in state court since the trial. Murdaugh will be appearing where Judge Clifton Newman will decide what happens next with the 100-plus financial crimes he's facing. What's the status on those? And will Newman be challenged in court by Murdaugh's attorneys? Don't forget, this is a huge part of this story now moving forward, because based on the filing that was dropped this week, there are multiple instances in which Judge Newman could be a fact witness, not only as it relates to the allegations against Clark Hill, but the controversy surrounding the dismissal of the juror on the day the verdict was announced. That morning, remember, the controversial dismissal of the so-called egg juror, we've got that. And reports that Newman read Clark Hill's book and gave it his okay prior to its publication. We've heard reports of that. That's going to potentially make Judge Newman a fact witness. But also beyond that, Judge Newman has made several public comments in the aftermath of the trial regarding his belief in Alec Murdaugh's guilt, particularly a speech he gave up at Cleveland State University, his alma mater, in the weeks after the trial, where he talked about the unimaginable, unspeakable crime that was committed. Can Judge Newman hear this case? And remember, there's a time crunch, too. At the end of this year, Judge Newman is done. He's off the bench. He's hitting the retirement age here in South Carolina and will no longer be a circuit court judge. So what happens at that point? Does Chief Justice Donald Beatty appoint another judge to handle this? And if you follow judges in South Carolina, you know that's a dicey proposition, people. Very dicey proposition. So much to follow in this story as it continues to unfold. FITSNews, the tip of the spear from the very beginning. The morning after those murders, we were the first news outlet to cover them, the first news outlet to report on who had been killed, first news outlet to report on all the major developments of this story, again, dating back years. Keep it tuned here, folks. We will keep you up to speed on the very latest breaking news, and not only that, but provide you with the analysis you need to make sense of it, and an open microphone to bring you the perspectives of everyone involved. No agendas, no egos, just the facts, just the truth, and just a search for true justice for all the victims in this case.